Ineffective Assistance of Counsel by Jonah Sanders. Introduction. What is ineffective assistance of counsel? Ineffective assistance of counsel refers to a situation where a criminal defendant's lawyer fails to provide competent or effective representation, resulting in the defendant being deprived of their constitutional right to a fair trial. The right to effective assistance of counsel is guaranteed by the Sixth Amendment of the United States Constitution. To prove ineffective assistance of counsel, the defendant must show that their attorney's performance was deficient and that this deficiency prejudiced the defense. In other words, the defendant must demonstrate that their lawyer's conduct was objectively unreasonable and that this conduct affected the outcome of the trial. Examples of ineffective assistance of counsel can include a failure to investigate important evidence or witnesses, a failure to object to improper evidence or testimony, a failure to adequately communicate with the defendant, or a conflict of interest that interferes with the lawyer's ability to provide effective representation. If a court finds that a defendant received ineffective assistance of counsel, the defendant may be granted a new trial or other relief, such as a reduced sentence. In some cases, ineffective assistance of counsel may also give rise to a legal malpractice claim against the lawyer. Course outline. 1. Introduction of ineffective assistance of counsel. 2. Example of ineffective assistance of counsel. 3. American Bar Association. 4. A defendant must show two things. 5. Some key points of ineffective assistance of counsel. 6. Procedural default doctrine and plea waivers. 7. Strickland ineffective assistance of counsel test. How to prove ineffective assistance of counsel. Module 1. Example of ineffective assistance of counsel. Ineffective assistance of counsel is a critical issue in the criminal justice system. It is a constitutional violation when a criminal defendant's attorney fails to provide effective representation during the trial, which results in the defendant being deprived of a fair trial. The Sixth Amendment of the United States Constitution guarantees every person accused of a crime the right to effective assistance of counsel. However, this right is often violated due to a variety of reasons such as inadequate resources, lack of experience, incompetence, conflicts of interest, and more. One of the most common examples of ineffective assistance of counsel is the failure of defense counsel to investigate and present mitigating evidence during sentencing. This can include evidence of the defendant's mental health, traumatic life experiences, or other factors that could reduce the severity of the sentence. Lesson 1. Definition of ineffective assistance of counsel. Unit A. Explain what ineffective assistance of counsel means in the context of criminal trials. Ineffective assistance of counsel refers to a situation in which a defendant in a criminal trial is provided with legal representation that falls below the minimum level of competence required by the Sixth Amendment of the United States Constitution. This means that the defendant's lawyer did not provide adequate representation during the trial, which may have resulted in a violation of the defendant's constitutional rights. This can occur in many ways, such as failing to investigate important facts, neglecting to call witnesses who could have provided key testimony, or giving incorrect legal advice. If a court finds that a defendant's attorney provided ineffective assistance, it may grant the defendant a new trial or other relief. Lesson 1. Unit B. Discuss the two-pronged test established in Strickland, Washington to determine ineffective assistance of counsel. In the landmark case of Strickland v. Washington, 1984, the Supreme Court established a two-pronged test to determine whether a defendant received ineffective assistance of counsel in a criminal trial. This test has become the standard for evaluating claims of ineffective assistance of counsel in the United States. The first prong of the Strickland test requires the defendant to show that their attorney's performance fell below an objective standard of reasonableness. This means that the defendant must demonstrate that their attorney's conduct was so deficient that it fell outside the range of professionally competent assistance. The second prong of the Strickland test requires the defendant to show that their attorney's deficient performance prejudiced their defense. This means that the defendant must demonstrate that there is a reasonable probability that, but for their attorney's errors, the outcome of the trial would have been different. To meet the first prong of the Strickland test, a defendant must show that their attorney's performance was deficient in some way. This may involve demonstrating that their attorney failed to investigate the case thoroughly, failed to challenge the prosecution's evidence or witnesses, or failed to provide effective cross-examination of witnesses. The standard for evaluating an attorney's performance is an objective one, meaning that the court will consider what a reasonably competent attorney would have done in the same situation. Lesson 2. Case Study. Strickland, Washington. Unit A. Discuss the background of the case and the legal issues at stake. Strickland v. Washington is a landmark case in United States constitutional law, specifically in the area of criminal procedure. The case was heard by the United States Supreme Court in 1984 and addressed the issue of ineffective assistance of counsel in criminal trials. The background of the case involves the trial and conviction of a man named James Lewis Strickland in Florida. Strickland was charged with and found guilty of the robbery and murder of a store clerk. He was sentenced to death, but his lawyers appealed his conviction on the grounds that his trial lawyer had provided ineffective assistance of counsel. The legal issue at stake in Strickland v. Washington was whether Strickland's trial lawyer had provided ineffective assistance of counsel in violation of the Sixth Amendment of the United States Constitution, which guarantees the right to counsel in criminal proceedings. In particular, the case raised the question of how to evaluate claims of ineffective assistance of counsel and the appropriate standard for such claims. Lesson 2. Unit B. Analyze the Supreme Court's decision and reasoning. In its decision, the Supreme Court established a two-pronged test to determine whether a defendant received ineffective assistance of counsel. The first prong requires the defendant to demonstrate that their lawyer's performance fell below an objective standard of reasonableness. The second prong requires the defendant to demonstrate that the deficient performance prejudiced the defense, meaning that there is a reasonable probability that the outcome of the trial would have been different had the lawyer provided effective assistance. The court found that Strickland's counsel had not provided effective assistance because they failed to conduct an adequate investigation, which led to important evidence not being presented at trial. The court noted that Strickland's counsel had failed to contact key witnesses and did not review important documents that could have helped the defense. However, the court ultimately held that Strickland had not been prejudiced by his lawyer's deficient performance. The court reasoned that, even if the omitted evidence had been presented at trial, it was not significant enough to undermine confidence in the outcome of the trial. The court noted that the prosecution had presented a strong case against Strickland and that the omitted evidence would not have changed the overall outcome. Lesson 2. Unit C. Examine the impact of the case on the legal system and criminal trials. Strickland v. Washington is a landmark case that has had a significant impact on the legal system and criminal trials. The case established a two-pronged test for determining whether a criminal defendant received ineffective assistance of counsel, which has become a standard for evaluating claims of ineffective assistance. Prior to the Strickland decision, courts applied a variety of different standards to evaluate ineffective assistance claims, with no clear guidance or consistency. The Supreme Court's decision in Strickland provided a uniform standard that could be applied in all cases. The two-pronged test established in Strickland requires that a defendant show both deficient performance by their attorney and that the deficient performance prejudiced the outcome of the trial. The first prong of the test requires the defendant to show that their attorney's representation fell below an objective standard of reasonableness. The second prong requires the defendant to show that there is a reasonable probability that, but for the deficient performance, the outcome of the trial would have been different. Since the Strickland decision, courts have applied this test to evaluate claims of ineffective assistance of counsel in a wide range of criminal cases. The decision has been cited in countless appeals and has influenced the way that criminal defense attorneys approach their representation of clients. One significant impact of the Strickland decision has been the increased attention given to the quality of representation provided by defense attorneys. Attorneys are now held to a higher standard, and there is greater scrutiny of their performance. The decision has also led to increased awareness of the importance of providing adequate legal representation to criminal defendants, particularly those who may not have the financial resources to hire private attorneys. Lesson 3. Examples of ineffective assistance of counsel. Lesson 3. Unit A. Provide examples of cases where the defendant claimed ineffective assistance of counsel. Strickland v. Washington, 1984. This landmark case established the two-pronged test to determine whether a defendant received ineffective assistance of counsel. The defendant in this case, Gary Strickland, argued that his lawyer failed to investigate mitigating evidence that could have helped him avoid the death penalty. Wiggins v. Smith, 2003. In this case, the defendant claimed that his lawyer failed to investigate and present evidence of his traumatic childhood during his sentencing hearing. The Supreme Court ultimately ruled that the lawyer's performance was deficient and that the defendant had been prejudiced as a result. State v. Counsel, 2017. In this case, the defendant claimed that his lawyer failed to provide adequate representation during his trial for murder. The defendant argued that his lawyer should have called an alibi witness and that his failure to do so constituted ineffective assistance of counsel. Lesson 3. Unit B. Analyze the outcomes of these cases and their impact on the legal system. There have been many cases where defendants have claimed ineffective assistance of counsel, and the outcomes have varied depending on the specifics of each case. Some notable examples include Gideon v. Wainwright, 1963. Clarence Earl Gideon was charged with breaking and entering a pool hall in Florida. He asked for a court-appointed attorney but was denied, and he was forced to represent himself. He was ultimately convicted and sentenced to 5 years in prison. He appealed to the Supreme Court, which ruled that the Sixth Amendment right to counsel applies to state criminal trials and that states are required to provide counsel for defendants who cannot afford one. This decision had a major impact on the legal system and has been credited with improving the quality of representation for defendants. Strickland v. Washington, 1984. This case established the two-pronged test for ineffective assistance of counsel. The defendant, Thomas Strickland, was convicted of murder and sentenced to death. He claimed that his trial attorney had failed to properly investigate and present mitigating evidence during the sentencing phase of his trial. The Supreme Court held that Strickland had to show that his attorney's performance was deficient and that the deficiency prejudiced the defense. This decision has had a significant impact on the legal system and is frequently cited in ineffective assistance of counsel cases. Roe v. Flores-Ortega, 2000. This case addressed the issue of whether an attorney's failure to file a notice of appeal constituted ineffective assistance of counsel. The defendant, Jose Angel Flores-Ortega, pleaded guilty to a drug charge but did not realize that he had the right to appeal his sentence. His attorney did not file a notice of appeal on his behalf, and Flores-Ortega later claimed that this constituted ineffective assistance of counsel. The Supreme Court held that an attorney's failure to file a notice of appeal is generally presumptively prejudicial, and the defendant only needs to show that he would have appealed if he had been properly advised. Padilla v. Kentucky, 2010. This case addressed whether an attorney's failure to advise a defendant of the immigration consequences of a guilty plea constituted ineffective assistance of counsel. The defendant, Jose Padilla, pleaded guilty to drug charges without being informed that the plea would result in his deportation. He later claimed that his attorney had been ineffective for failing to advise him of this consequence. The Supreme Court held that the Sixth Amendment requires defense attorneys to advise non-citizen clients of the deportation risks associated with a guilty plea. This decision has had a significant impact on the legal system and has led to changes in the way that defense attorneys advise their clients. Lesson 4. Challenges to proving ineffective assistance of counsel. Lesson 4 Unit A. Discuss the challenges defendants face in proving ineffective assistance of counsel. Proving ineffective assistance of counsel can be challenging for defendants due to several factors. Here are some of the challenges defendants may face. High standard of proof. To successfully prove ineffective assistance of counsel, defendants must meet the two-pronged test established in Strickland v. Washington. This requires showing that their counsel's performance was deficient and that the deficient performance prejudiced the defense. The burden of proof is on the defendant, and they must show that there is a reasonable probability that the outcome of the trial would have been different if their counsel had not performed deficiently. Limited review. Courts are hesitant to second-guess the strategic decisions made by defense counsel during trial. The mere fact that a different strategy could have been used or that a different outcome might have resulted does not necessarily prove ineffective assistance of counsel. Waiver of claims. Defendants who pled guilty or signed plea agreements may be waiving their right to later claim ineffective assistance of counsel. This is because the plea agreement typically includes a provision in which the defendant waives their right to appeal the case or raise other claims related to the case. Difficulty in finding new counsel. Defendants who claim ineffective assistance of counsel may need to find new counsel to represent them in the case. However, this can be challenging as new counsel may be hesitant to take on a case in which they are accusing another lawyer of being ineffective. Statute of limitations. Some jurisdictions have statutes of limitations that limit the time frame in which a defendant can bring a claim of ineffective assistance of counsel. This can further limit a defendant's ability to make such a claim. Lesson 4. Unit B. Examine the role of appellate courts in reviewing claims of ineffective assistance of counsel. Appellate courts play an important role in reviewing claims of ineffective assistance of counsel. In many cases, a defendant will appeal a conviction or sentence, arguing that their trial lawyer provided ineffective assistance, which violated their constitutional rights. When reviewing such claims, appellate courts will typically apply the two-pronged test established in Strickland v. Washington. This test requires the defendant to show that their lawyer's performance was deficient and that this deficiency resulted in prejudice to the defendant's case. Appellate courts will generally review the trial record and other relevant evidence to determine whether the defendant has met their burden of proof under Strickland. In some cases, an appellate court may order a new trial or other relief if it finds that the defendant's lawyer provided ineffective assistance. However, appellate courts generally give deference to the trial court's findings of fact and legal conclusions, which can make it difficult for defendants to prevail on claims of ineffective assistance of counsel. Additionally, the high standard of proof required to meet the Strickland test means that defendants face significant challenges in demonstrating that their lawyer's performance fell below acceptable standards and caused them prejudice. Module 2 American Bar Association. The American Bar Association, ABA, has issued guidelines for attorneys in order to ensure that they provide effective assistance of counsel to their clients. These guidelines, known as the ABA Standards for Criminal Justice, provide a framework for attorneys to follow in order to meet their ethical and professional responsibilities to their clients. Lesson 1. Some key provisions of the ABA Standards for Criminal Justice include: competence. Attorneys are expected to possess the legal knowledge, skill, thoroughness, and preparation necessary to represent their clients effectively. Communication. Attorneys are expected to maintain regular communication with their clients and to keep them informed about the status of their case. Confidentiality. Attorneys are expected to maintain the confidentiality of their clients' information and to avoid conflicts of interest. Investigation. Attorneys are expected to conduct a thorough investigation of the facts and evidence in their clients' cases in order to make informed decisions about legal strategy. Zealous representation. Attorneys are expected to represent their clients zealously, within the bounds of the law and ethical obligations. Consultation. Attorneys are expected to consult with experts and other professionals when necessary to provide effective representation to their clients. Plea negotiations. Attorneys are expected to negotiate plea agreements in the best interests of their clients and to keep them informed about the potential consequences of any plea offer. Lesson 2. Legal Ethics and Professional Responsibility. Unit A. ABA Model Rules of Professional Conduct. The American Bar Association, ABA, Model Rules of Professional Conduct is a set of ethical rules and guidelines that govern the professional conduct of lawyers in the United States. The model rules were first adopted by the ABA in 1983 and have been revised several times since then. They serve as a model for many state bar associations, which have adopted variations of the model rules as their own professional conduct rules. The model rules are divided into several parts, including rules related to client-lawyer relationships, confidentiality of client information, conflicts of interest, and duties to the legal profession and the public. The rules are designed to protect clients' interests while maintaining the integrity and professionalism of the legal system. Lawyers who violate the model rules of professional conduct can face disciplinary action from their state bar association, which can include sanctions ranging from a reprimand to disbarment. Some violations of the rules can also result in criminal charges or civil liability. Overall, the ABA model rules of professional conduct play an important role in regulating the conduct of lawyers in the United States and ensuring that clients receive ethical and competent legal representation. Lesson 2. Unit B. Ethical considerations for lawyers. Lawyers are held to high ethical standards due to the important role they play in the legal system. Ethical considerations for lawyers include confidentiality. Lawyers are required to keep client information confidential. They must not disclose any information that may harm their client's interests, except in certain limited circumstances such as when the client consents or when disclosure is required by law. Conflict of interest. Lawyers must avoid conflicts of interest that may arise from their representation of clients. This means that they cannot represent clients with opposing interests or have personal interests that may interfere with their representation of their clients. Competence. Lawyers are expected to possess the legal knowledge and skills necessary to provide competent representation to their clients. They must also stay current with legal developments that may affect their clients. Candor. Lawyers must be truthful and candid with their clients, the courts, and other parties. They cannot misrepresent facts or law, or make false statements. Zealous advocacy. Lawyers must represent their clients zealously within the bounds of the law. This means that they must act in their clients' best interests, but also follow ethical rules and standards. Fees and expenses. Lawyers must ensure that their fees are reasonable and not excessive. They must also disclose all expenses and fees to their clients in advance. Professionalism. Lawyers must conduct themselves in a professional manner and treat all parties with respect. They cannot engage in behavior that reflects poorly on the legal profession. These ethical considerations are codified in various professional codes of conduct, such as the ABA Model Rules of Professional Conduct, and are enforced by state bar associations and disciplinary authorities. Lawyers who violate ethical rules may face disciplinary action, including suspension or revocation of their license to practice law. Lesson 2. Unit C. ABA Standing Committee on Ethics and Professional Responsibility. 1. The ABA Standing Committee on Ethics and Professional Responsibility is a committee within the American Bar Association that is responsible for providing guidance to lawyers and judges on ethical issues and professional conduct. The committee is made up of a group of lawyers and judges who are appointed by the ABA president and who serve 3-year terms. 2. The committee issues formal opinions on a wide range of topics related to legal ethics, including conflicts of interest, confidentiality, advertising and solicitation, and the duty to provide competent representation. These opinions provide guidance to lawyers and judges on how to comply with the ABA Model Rules of Professional Conduct and other ethical standards. 3. In addition to issuing formal opinions, the committee also provides informal guidance to lawyers and judges through its hotline and other resources. The committee also works to promote awareness of ethical issues and professional conduct standards through training programs, publications, and other initiatives. Lesson 3. Legal Education and Admissions to the Bar. Lesson 3 Unit A. Accreditation of Law Schools. Accreditation of law schools refers to the process by which an independent agency evaluates and verifies that a law school meets certain predetermined standards of quality and excellence in legal education. In the United States, the American Bar Association, ABA, is the primary accrediting body for law schools. The ABA's section of Legal Education and Admissions to the Bar is responsible for administering the accreditation process, which involves a comprehensive review of a law school's curriculum, faculty, facilities, student services, and other factors. To obtain and maintain ABA accreditation, law schools must meet a set of rigorous standards that are designed to ensure that students receive a high-quality legal education that prepares them for the practice of law. The standards cover a wide range of areas, including curriculum, faculty, admissions, library and information resources, student services, and facilities. Law schools must also demonstrate that they are committed to promoting diversity and inclusivity in their student body and faculty, and that they have adequate systems in place for assessing and improving the quality of their programs. Accreditation by the ABA is not mandatory for a law school to operate, but it is highly valued by students, employers, and the legal community. Graduation from an ABA-accredited law school is a requirement for admission to the bar in most U.S. States and employers often prefer to hire graduates of accredited schools. In addition, many law schools require accreditation in order to be eligible for federal student financial aid programs. The ABA accreditation process involves both initial and periodic evaluations of law schools. Schools seeking initial accreditation must submit a self-study report and undergo a site visit by a team of evaluators. After the evaluation, the ABA's accreditation committee will make a recommendation on whether the school should be accredited. Once accredited, law schools must undergo periodic reviews to ensure that they continue to meet the ABA's standards. Lesson 3. Unit B. Standard 509 Disclosure Requirements. Standard 509 disclosure requirements refer to the American Bar Association's ABA standards for law schools that require them to disclose certain information on their websites to prospective and current students, as well as other interested parties. These requirements aim to provide transparency and clarity about the school's admissions data, tuition and fees, curriculum, faculty, and other relevant information. The Standard 509 requires that all accredited law schools in the United States make the following information publicly available on their website. 1. Admissions data. Information about the number of applicants, the number of students admitted, and the LSAT and GPA scores of the admitted students. 2. Tuition and fees. Information about the total cost of attendance, including tuition, fees, and estimated living expenses, as well as information about scholarships and other financial aid opportunities. 3. Curriculum. Information about the required courses, electives, and experiential learning opportunities offered by the law school. 4. Faculty. Information about the number of full-time and part-time faculty members, their qualifications, and areas of expertise. 5. Library and technology resources. Information about the law school's library and technology resources available to students. Employment outcomes. Information about the employment outcomes of the school's graduates, including their employment. 6. Rates, types of employment, and salaries. 7. Bar passage rates. Information about the school's bar passage rates for first-time test takers. 8. By providing this information, law schools aim to give students a clearer picture of what they can expect from their legal education and to help them make informed decisions about where to apply and ultimately attend law school. Lesson 3. Unit C. ABA section of Legal Education and Admissions to the Bar. The ABA section of Legal Education and Admissions to the Bar is responsible for the accreditation of law schools in the United States. It was established by the ABA in 1952 to promote high-quality legal education and establish standards for law schools. The section's main functions include reviewing and accrediting law schools, developing and implementing standards for legal education, and providing guidance and support to law schools in meeting those standards. The section also works with state bar admission authorities to establish uniform requirements for admission to the bar. Overall, the section plays a crucial role in ensuring the quality of legal education in the United States and maintaining high standards for the legal profession. Lesson 4. Access to Justice. Lesson 4 Unit A. Pro bono work and legal aid services. 1. Pro bono work refers to legal services provided by lawyers to clients who cannot afford to pay for such services. Legal aid services, on the other hand, are legal services provided to low-income individuals who cannot afford to pay for legal representation. 2. Pro bono work and legal aid services are essential for ensuring access to justice for low-income individuals who may not otherwise have the resources to obtain legal representation. These services can help ensure that everyone has equal access to the legal system, regardless of their financial circumstances. 3. Many law firms and individual lawyers participate in pro bono work, often partnering with legal aid organizations or providing services directly to clients in need. In some cases, lawyers are required to complete a certain number of pro bono hours as part of their ethical obligations. 4. Legal aid organizations, which are often nonprofit organizations, provide free or low-cost legal services to low-income individuals. These organizations often focus on specific areas of law, such as housing or immigration, and may work with volunteer lawyers or have staff attorneys. 5. While pro bono work and legal aid services are important for increasing access to justice, they are not a substitute for comprehensive legal aid funding and a strong public defender system. Many low-income individuals still face barriers to accessing legal representation and may struggle to navigate the legal system without adequate support. Lesson 4. Unit B. ABBA Standing Committee on Legal Aid and Indigent Defendants. The ABBA Standing Committee on Legal Aid and Indigent Defendants is a standing committee of the American Bar Association that focuses on issues related to the provision of legal services to low-income individuals and indigent defendants. The committee's work includes advocating for policies and programs that increase access to legal services for those in need, providing resources and support to legal aid organizations and pro bono programs, and promoting best practices in the representation of indigent defendants in the criminal justice system. The committee also works to educate lawyers and the public about the importance of ensuring that all individuals have access to legal representation, regardless of their financial circumstances. Lesson 4. Unit C. ABBA Section of Litigations Access to Justice Committee. 1. The ABBA Section of Litigations Access to Justice Committee is a committee dedicated to promoting and advancing access to justice initiatives. The committee is comprised of lawyers and other legal professionals who work to address the justice gap and ensure that all individuals, regardless of income or social status, have access to legal representation and a fair justice system. 2. The committee engages in a variety of activities to further this goal, including advocating for policy changes, providing resources and training to lawyers, and supporting pro bono initiatives. They also work to raise awareness of the challenges facing vulnerable and marginalized communities in the justice system and seek to address these challenges through education and collaboration with other organizations. Overall, the Access to Justice Committee plays an important role in promoting greater access to justice and equity in the legal system. Lesson 5. Judicial Administration. Lesson 5 Unit A. Judicial Independence and Impartiality. 1. Judicial independence and impartiality are critical components of a fair and effective justice system. Judicial independence refers to the ability of judges to make decisions free from political or external influence. It ensures that judges can interpret and apply the law impartially, without fear of reprisal or retaliation. 2. Impartiality, on the other hand, means that judges must be fair and unbiased when deciding cases. They must consider only the relevant facts and evidence presented in the case, and not be influenced by personal biases or outside factors. 3. Judicial independence and impartiality are essential to uphold the rule of law and maintain public trust in the justice system. Judges must be able to make decisions based solely on the law and facts of a case, without being swayed by external pressures or personal beliefs. 4. To ensure judicial independence and impartiality, many countries have established systems for appointing and removing judges that minimize political interference. For example, in the United States, federal judges are appointed by the President and confirmed by the Senate, and can only be removed through impeachment by Congress. Additionally, judges are required to recuse themselves from cases where they may have a conflict of interest or bias. 5. Maintaining judicial independence and impartiality requires ongoing vigilance and support from the legal community, as well as from the public and government officials. It is essential to protect the integrity of the justice system and ensure that it serves the needs of all people equally. Lesson 5. Unit B. Judicial Ethics and Conduct. 1. Judicial ethics and conduct refers to the standards and principles that guide the behavior of judges in their official capacities. These standards are aimed at ensuring that judges remain impartial, fair, and independent in carrying out their duties. 2. Judges are expected to follow ethical guidelines to maintain public trust and confidence in the judiciary. In the United States, the American Bar Association (ABBA) Model Code of Judicial Conduct serves as a model for states to follow in establishing their own ethical standards for judges. 3. The ABBA Model Code outlines various ethical considerations, including the requirement that judges maintain impartiality and avoid conflicts of interest, that they conduct themselves in a manner that promotes public confidence in the integrity and impartiality of the judiciary, and that they uphold the law and the principles of judicial independence. 4. Judges are also expected to avoid improper behavior or conduct that could undermine the public's trust in the judiciary. This includes avoiding engaging in political activity, accepting gifts or favors that could appear to influence their decisions, and disclosing any personal or financial interests that could affect their impartiality. 5. Additionally, Judges must be mindful of the appearance of impropriety, even if there is no actual impropriety. This means that judges should avoid even the perception of bias or partiality, and conduct themselves in a manner that promotes confidence in the judiciary. 6. Violation of ethical guidelines can result in disciplinary action, including removal from the bench, suspension, or reprimand. It is important for judges to maintain ethical conduct to ensure the fair and impartial administration of justice. Lesson 5. Unit C. ABA Section of Judicial Administration. 1. The ABA section of judicial administration is a section of the American Bar Association that focuses on improving the administration of justice in the United States. It is one of the largest and most influential sections of the ABA and includes judges, court administrators, and other legal professionals. 2. The section provides a forum for members to exchange ideas and best practices for the management and administration of the judicial system. It also promotes judicial independence, impartiality, and ethical conduct among judges, court personnel, and other legal professionals. The section is involved in a wide range of activities and initiatives, including research, education, and advocacy efforts. It also provides training and professional development opportunities for judges and court personnel. Module 3A. Defendant must show 2 things. Ineffective assistance of counsel is a legal term used to describe a situation where a criminal defendant's lawyer fails to provide effective representation during the criminal trial, which results in the defendant being deprived of his or her constitutional right to a fair trial. To raise a claim of ineffective assistance of counsel, a defendant must do so in a timely manner, typically by filing a motion for a new trial or an appeal. The defendant must also provide specific examples of the lawyer's deficient performance and how it prejudiced the defense. If a court finds that a defendant's lawyer provided ineffective assistance, the defendant may be granted a new trial or other relief, such as a reduced sentence. Lesson 1. Deficient performance. What is deficient performance? The defendant must first show that their attorney's performance fell below an objective standard of reasonableness. In other words, the defendant must show that their attorney's performance was so inadequate that it deprived the defendant of a fair trial. This can include a wide range of factors, such as failing to conduct an adequate investigation, failing to call relevant witnesses, or making significant legal errors. Unit A. Failure of an attorney to provide a quality of representation consistent with professional norms. 1. The failure of an attorney to provide a quality of representation consistent with professional norms is a form of legal malpractice. Legal malpractice occurs when an attorney breaches their duty of care to a client, resulting in damages to the client. In the context of legal representation, the duty of care requires attorneys to provide competent and diligent representation to their clients. This means that attorneys must have the necessary knowledge, skill, and experience to handle their clients' cases and must work diligently to represent their clients' interests. 2. If an attorney fails to provide a quality of representation consistent with professional norms, they may be held liable for legal malpractice. Examples of such failures include missing deadlines, failing to file necessary paperwork, providing incorrect advice, and failing to adequately prepare for a case. In order to prove legal malpractice, the client must show that the attorney's actions or omissions fell below the standard of care expected of a reasonably competent attorney, and that this breach caused the client to suffer damages. 3. Legal malpractice cases can be complex and difficult to prove, and often require the involvement of expert witnesses to establish the appropriate standard of care and demonstrate the attorney's breach of that standard. The damages that may be awarded in a legal malpractice case can vary widely, but typically include the costs of rectifying the harm caused by the attorney's actions or omissions, such as legal fees or lost opportunities, as well as damages for emotional distress or other non-economic harms. Unit B. What are the key factors in assessing deficient performance? Whether the attorney's actions fell below an objective standard of reasonableness. The first prong of the Strickland test requires the defendant to show that their attorney's actions fell below an objective standard of reasonableness. In other words, the defendant must demonstrate that their attorney's performance was deficient in light of the prevailing professional norms at the time of the representation. To determine whether an attorney's actions were objectively unreasonable, the court will consider the totality of the circumstances, including the complexity of the case, the available evidence, the relevant law, and the prevailing professional norms in the jurisdiction. The court will also consider whether the attorney made any strategic decisions that, while ultimately unsuccessful, were nevertheless reasonable at the time they were made. Courts give attorneys a great deal of leeway in making strategic decisions, as long as those decisions are based on reasonable professional judgment. Attorneys are not expected to be perfect, and even the most skilled and experienced lawyers can make mistakes. However, if an attorney's errors were so serious that they fell below an objective standard of reasonableness, the defendant may be able to prove deficient performance under the first prong of the Strickland test. Whether the attorney made errors or omissions that affected the outcome of the case. Yes, whether the attorney's errors or omissions affected the outcome of the case is a key factor in determining ineffective assistance of counsel. This is because an attorney's performance, even if deficient, must have actually resulted in prejudice to the defendant in order for a claim of ineffective assistance of counsel to be successful. Therefore, the court must examine whether the errors or omissions were significant enough to have affected the outcome of the case. In addition, the court will also consider whether the attorney's actions were within the bounds of reasonable professional judgment, based on the circumstances of the case. If the attorney's actions were objectively reasonable and did not cause prejudice to the defendant, then there is no claim for ineffective assistance of counsel. Whether the attorney conducted a reasonable investigation in preparation for the case. Yes, whether the attorney conducted a reasonable investigation in preparation for the case is a factor in determining whether the attorney's actions fell below an objective standard of reasonableness. This is because a thorough investigation and preparation are crucial for providing effective representation to the client and presenting a strong defense. An attorney who fails to investigate important evidence or prepare adequately for trial may be considered to have provided deficient performance, especially if such omissions affected the outcome of the case. Whether the attorney's decisions and actions were strategic and reasonable. Yes, another factor that courts consider when evaluating an ineffective assistance of counsel claim is whether the attorney's decisions and actions were strategic and reasonable under the circumstances. Attorneys have a duty to make strategic decisions about how to handle a case, such as which evidence to present, which witnesses to call, and how to cross-examine witnesses. These decisions are often based on a careful evaluation of the evidence and the strengths and weaknesses of the case. When evaluating an ineffective assistance of counsel claim, courts consider whether the attorney's strategic decisions were reasonable under the circumstances and whether they were based on a thorough investigation and preparation for the case. If an attorney made reasonable strategic decisions that were based on a thorough investigation, even if those decisions did not ultimately lead to a favorable outcome for the defendant, the attorney may not be found to have provided ineffective assistance of counsel. Unit C. What are some examples of deficient performance? Failure to investigate crucial evidence or witnesses. A common example of deficient performance by an attorney is the failure to investigate crucial evidence or witnesses. This can occur when an attorney fails to review important documents, interview potential witnesses, or follow up on leads that may be relevant to the case. For example, if a defendant is accused of committing a crime in a particular location, but the defense attorney fails to investigate whether there were any surveillance cameras in the area that may have captured evidence of the incident, this could be considered deficient performance. Similarly, if a defense attorney fails to interview a witness who may have information that could exonerate the defendant or provide important context to the case, this could also be considered deficient performance. Failure to investigate crucial evidence or witnesses can result in prejudice to the defendant, as it may lead to the failure to present a complete and accurate picture of the case to the court. Without this evidence, the defendant's case may be weaker, and the defendant may be more likely to be found guilty or receive a harsher sentence. Failure to challenge unconstitutional evidence or violations of the defendant's rights. Failing to challenge unconstitutional evidence or violations of the defendant's rights can also be an example of deficient performance by an attorney. This can include failing to object to evidence obtained through an illegal search or seizure, or failing to challenge statements made by the defendant that were obtained in violation of their Miranda rights. An attorney's failure to protect their client's constitutional rights can have a significant impact on the outcome of the case and can result in a finding of ineffective assistance of counsel if the defendant can demonstrate resulting prejudice. Failure to object to improper statements or evidence during the trial. Failure to object to improper statements or evidence during the trial is another example of deficient performance that can lead to an ineffective assistance of counsel claim. Attorneys have a duty to object to improper statements or evidence presented during the trial, such as hearsay or evidence obtained through an illegal search and seizure. Failure to do so can result in the evidence being admitted and potentially affecting the outcome of the case. In such cases, the defendant may argue that the attorney's failure to object fell below an objective standard of reasonableness and resulted in prejudice, such as an unfair conviction or harsher sentence. Failure to prepare a strong defense strategy or call necessary witnesses. Yes, failure to prepare a strong defense strategy or call necessary witnesses can also be considered deficient performance by an attorney in an ineffective assistance of counsel claim. An attorney has a duty to conduct a reasonable investigation and preparation for the case, and this includes identifying and calling necessary witnesses who can provide relevant testimony in support of the defendant's case. Failure to do so may constitute deficient performance and can prejudice the defendant's case. Failure to adequately communicate with the defendant or keep them informed about their case. Failure to adequately communicate with the defendant or keep them informed about their case is another potential example of deficient performance by an attorney. This can include failing to explain the charges against the defendant and the potential consequences of a conviction. Discuss the available legal options and the risks and benefits of each option. Keep the defendant informed about the progress of their case and any important updates or developments. Respond promptly and effectively to the defendant's questions and concerns. Make the defendant aware of any plea bargain offers or opportunities for negotiation with the prosecution. If an attorney fails to communicate effectively with their client, it can lead to misunderstandings, missed opportunities, and a breakdown in the attorney-client relationship, which can ultimately harm the defendant's case. Lesson 2. Prejudice. Even if the defendant can establish that their attorney's performance was deficient, they must also show that this deficient performance actually prejudiced the outcome of the trial. Specifically, the defendant must show that there is a reasonable probability that, but for their attorney's deficient performance, the outcome of the trial would have been different. This requires the defendant to show that there is a reasonable probability that they would have been acquitted or received a more favorable outcome at trial had their attorney not performed deficiently. Unit A. The defendant must show that the deficient performance of their counsel prejudiced the outcome of the trial. This means that the outcome of the trial would have been different if the lawyer had provided effective assistance. Unit B. There are two ways to show prejudice. The first is by demonstrating that the lawyer's errors were so serious that the defendant did not receive a fair trial. The second is by showing that there is a reasonable probability that, but for the lawyer's errors, the result of the trial would have been different. Unit C. To establish prejudice, the defendant must show that there is a reasonable probability that the result of the trial would have been different if the lawyer had not made the errors. This means that the defendant does not need to show that the outcome of the trial would have been more likely than not to have been different, but only that the result would have been different enough to undermine confidence in the outcome of the trial. Module 4. Some key points of ineffective assistance of counsel. Lesson 1. Deficient performance. Lesson 1. Unit A. Examples of deficient performance by an attorney may include 1. Failing to investigate the facts of the case thoroughly. 2. Failing to research and apply the relevant law to the case adequately. 3. Failing to communicate with the client effectively and keep them informed of important developments in the case. 4. Failing to present a strong defense at trial or to make effective arguments during plea negotiations. 5. Failing to object to improper evidence or argument by the prosecutor. 6. Failing to file important motions or to meet important deadlines in the case. 7. Failing to consult with or call appropriate witnesses. 8. Failing to adequately prepare for trial or other court appearances. 9. Failing to raise important legal issues on appeal. 10. Failing to provide the client with competent legal advice, including advice on plea negotiations and the potential consequences of a conviction. Lesson 1. Unit B. Failing to investigate or present important evidence. Failing to investigate or present important evidence can be an example of deficient performance by an attorney. Attorneys have a duty to conduct a thorough investigation of their client's case and to present all relevant evidence to the court. This includes interviewing witnesses, reviewing police reports and other documents, and conducting research on legal issues related to the case. If an attorney fails to investigate or present important evidence, it can significantly harm their client's case and result in an unfair outcome. For example, if an attorney fails to interview a key witness who could provide exculpatory evidence, or fails to present a critical piece of evidence at trial, their client may be convicted or receive a less favorable outcome. Lesson 1. Unit C. Providing incorrect legal advice. Providing incorrect legal advice is an example of deficient performance by an attorney. It occurs when an attorney provides advice that is incorrect or based on a misinterpretation of the law, which may have negative consequences for the client. For example, if an attorney advises their client to plead guilty to a charge without fully understanding the implications of the plea or the strength of the evidence against the client, this could be considered deficient performance. Similarly, if an attorney advises their client to take a certain legal action that is not supported by the law, the attorney may be providing deficient performance. Lesson 1. Unit D. Failing to communicate with the defendant. Failing to communicate with the defendant can also be an example of deficient performance by an attorney. This can include failing to keep the defendant informed about important developments in their case, failing to explain the legal process or strategy, or failing to obtain the defendant's input or consent on important decisions. This lack of communication can ultimately harm the defendant's case and their ability to make informed decisions about their defense. Lesson 1. Unit E. Failing to prepare adequately for trial. Failing to prepare adequately for trial refers to a situation where an attorney does not properly prepare for a trial despite the availability of sufficient time and resources. This may include failing to conduct an investigation, failure to interview or call important witnesses, failure to identify and prepare legal defenses, or failure to properly analyze and use evidence. In addition, an attorney may fail to effectively cross-examine witnesses or make persuasive arguments during the trial. This can result in a weaker defense for the defendant and an increased likelihood of a negative outcome. Lesson 1. Unit F. Failing to call or cross-examine witnesses. Failing to call or cross-examine witnesses is another example of deficient performance by an attorney. In a criminal trial, witnesses play a crucial role in presenting evidence and establishing the facts of the case. A defense attorney has a duty to identify relevant witnesses, interview them, and decide which witnesses to call to the stand. If an attorney fails to call a material witness or fails to cross-examine a witness who testifies against the defendant, it may weaken the defendant's case and result in an unfavorable outcome. Lesson 2. Prejudice. Lesson 1. Unit A. Examples of prejudice that may result from deficient performance by an attorney may include. Some examples of prejudice that may result from deficient performance by an attorney include 1. A conviction that could have been avoided with proper legal advice or representation. 2. A longer prison sentence or harsher penalty than what would have been imposed with better representation. 3. Loss of legal rights or privileges, such as the right to vote or own a firearm. 4. Damage to reputation, career, or personal relationships due to a conviction or legal action that could have been avoided. 5. Loss of employment or housing opportunities due to a criminal record that could have been avoided or minimized with better representation. 6. Increased financial burden due to fines, restitution, or other penalties that could have been reduced with better representation. Lesson 1. Unit B. A guilty verdict when the defendant may have been found not guilty with adequate representation. Yes, that is a possible example of prejudice that may result from deficient performance by an attorney. If the attorney failed to investigate or present important evidence or failed to prepare adequately for trial, for example, it could lead to a guilty verdict even if the defendant was not actually guilty. This would be a result of the attorney's deficient performance, and the defendant may have been found not guilty if the attorney had provided adequate representation. Lesson 1. Unit C. A harsher sentence than the defendant may have received with adequate representation. Yes, that is a possible example of prejudice resulting from deficient performance by an attorney. If the attorney fails to present mitigating factors or negotiate a favorable plea deal, the defendant may receive a harsher sentence than they would have with adequate representation. This is why it is important for attorneys to provide effective representation to their clients. Lesson 3. Burden of proof. Lesson 1. Unit A. The burden of proof rests with the defendant to prove both deficient performance and prejudice in an ineffective assistance of counsel claim. Yes, that is correct. In order to succeed on an ineffective assistance of counsel claim, the defendant must prove both deficient performance and resulting prejudice. The burden of proof rests with the defendant to show that their attorney's performance fell below an objective standard of reasonableness, and that this deficiency resulted in a fundamentally unfair trial or sentencing proceeding that deprived them of their constitutional right to effective assistance of counsel. Lesson 1. Unit B. The defendant must provide evidence that their attorney's performance fell below the standard of reasonableness and that it affected the outcome of the trial. Yes, that is correct. In an ineffective assistance of counsel claim, the defendant must show that their attorney's performance was deficient and that this deficiency resulted in prejudice. The defendant must provide evidence to show that their attorney's performance fell below an objective standard of reasonableness, which means that it was not merely a strategic decision or mistake. Additionally, the defendant must show that there is a reasonable probability that, but for the deficient performance, the outcome of the trial would have been different. This means that the defendant must demonstrate that the deficient performance affected the outcome of the trial in a significant way. The burden of proof is on the defendant to establish both deficient performance and resulting prejudice. Lesson 4. Impact on criminal justice system. Lesson 1. Unit A. Ineffective assistance of counsel claims can have a significant impact on the criminal justice system. Yes, ineffective assistance of counsel claims can have a significant impact on the criminal justice system. They can lead to the reversal of convictions, new trials, and even changes in the way the legal system operates. When defendants are not provided with competent legal representation, it undermines the fairness and accuracy of the criminal justice system. It also undermines public confidence in the system and can erode the legitimacy of the legal process. As such, it is important that defendants have access to effective legal representation and that attorneys are held accountable for providing competent and zealous representation. Lesson 1. Unit B. The Supreme Court's decision in Strickland v. Washington established a high standard for defendants to meet in order to prove ineffective assistance of counsel, which can make it difficult to succeed with such claims. Yes, that's correct. The Strickland test requires a defendant to show not only that their attorney's performance was deficient, but also that it resulted in prejudice. This can be a high standard to meet, as it requires a defendant to demonstrate that there is a reasonable probability that the outcome of their trial would have been different had their attorney not performed deficiently. Additionally, courts tend to give a great deal of deference to an attorney's tactical decisions, which can make it even harder to succeed on an ineffective assistance of counsel claim. As a result, such claims are not always successful, and defendants may need to explore other avenues for relief, such as appeals based on errors made by the trial court. Lesson 1. Unit C. However, when successful, these claims can lead to a new trial or a change in sentencing for the defendant, highlighting the importance of competent and adequate legal representation for all defendants. Yes, that is correct. The ability to prove ineffective assistance of counsel can have significant implications for defendants, as it can result in a new trial or a change in sentencing. This underscores the importance of ensuring that all defendants have access to competent and effective legal representation, regardless of their financial means or other circumstances. The legal system relies on the principle that all defendants are entitled to a fair trial and representation, and claims of ineffective assistance of counsel play a crucial role in upholding this principle. Module 5. Procedural Default Doctrine and Plea Waivers. The procedural default doctrine is a legal principle that prevents a defendant from raising an argument on appeal if the argument was not raised during the trial. The doctrine is based on the idea that a defendant must first give the trial court an opportunity to correct any errors before seeking review from a higher court. A plea waiver is an agreement between a defendant and the prosecution where the defendant agrees to waive certain rights, such as the right to a trial or the right to appeal, in exchange for a plea deal. In some cases, a plea waiver may also include a provision that waives the defendant's right to raise certain arguments on appeal. The procedural default doctrine and plea waivers can intersect in cases where a defendant seeks to raise an argument on appeal that was not raised during the trial. If the argument is one that was waived in a plea agreement, the defendant may be barred from raising the argument on appeal under the doctrine of procedural default. Lessoni. 1. Procedural Default Doctrine. Unit A. The procedural default doctrine refers to the principle that a federal court will not consider an issue raised by a habeas corpus petitioner if the state court has already decided the issue on an independent and adequate state law ground. Unit B. In other words, if the state court has rejected a claim because it was procedurally barred, such as because the defendant failed to raise the issue at the appropriate time, the federal court will not consider the claim in a habeas corpus proceeding. Unit C. The procedural default doctrine is based on the idea that federal courts should generally respect the finality of state court judgments and not second-guess the state court's application of its own rules. Unit D. However, there are exceptions to the procedural default doctrine, such as if the petitioner can show cause and prejudice for the procedural default, or if the petitioner can show that the failure to consider the claim would result in a fundamental miscarriage of justice. Lessoni. 2. Plea Waivers. Unit A. A plea waiver is a provision in a plea agreement that requires the defendant to waive certain rights, such as the right to appeal, in exchange for a more lenient sentence. Unit B. Plea waivers are common in criminal cases and can help streamline the criminal justice process by reducing the number of appeals and post-conviction proceedings. Unit C. However, plea waivers can also raise concerns about due process and the defendant's right to a fair trial, as the defendant may be pressured to waive important rights in order to avoid a harsher sentence. Unit D. Courts generally enforce plea waivers as long as they are knowing and voluntary, meaning that the defendant understands the consequences of the waiver and enters into it voluntarily and intelligently. Unit E. However, there are limits to the enforceability of plea waivers, such as if the waiver violates public policy, or if the defendant can show that the waiver was involuntary or the result of ineffective assistance of counsel. Module 6. Strickland Ineffective Assistance of Counsel Test. How to prove ineffective assistance of counsel. To prove ineffective assistance of counsel, a defendant must satisfy a two-pronged test established by the Supreme Court in Strickland v. Washington. The Strickland test requires the defendant to show both deficient performance by their attorney and resulting prejudice. Lessoni. 1. Deficient performance. The first prong of the Strickland test requires the defendant to show that their attorney's performance was deficient, meaning that it fell below the objective standard of reasonableness expected of attorneys. To establish deficient performance, the defendant must show that their attorney made errors that were so serious that they did not function as the counsel guaranteed by the Sixth Amendment. Examples of deficient performance might include failing to investigate important evidence or witnesses, failing to object to improper evidence or testimony, providing incorrect legal advice, failing to communicate with the defendant, or providing ineffective cross-examination of witnesses. Lesson 1. Unit A. Reasonable standard of care. To prove deficient performance, the defendant must show that their lawyer's performance was below the standard of care expected from a reasonable attorney. This means that the lawyer's actions or inactions must be shown to have fallen below what is considered acceptable in the legal profession. Lesson 1. Unit B. Trial strategy. In some cases, a lawyer may make strategic decisions that are not effective, but are still reasonable under the circumstances. A defendant cannot prove deficient performance simply because they disagree with their lawyer's trial strategy. To prove deficient performance, the defendant must show that the lawyer's actions or inactions were not based on any reasonable trial strategy. Lesson 1. Unit C. Investigation and preparation. A lawyer has a duty to investigate and prepare for the case. This includes reviewing evidence, interviewing witnesses, and developing a theory of the case. If a lawyer fails to investigate or prepare adequately, it can constitute deficient performance. Lesson 1. Unit D. Communication. A lawyer has a duty to communicate with their client and keep them informed of the progress of their case. If a lawyer fails to communicate with their client, it can constitute deficient performance. Lesson 1. Unit E. Other actions or inactions. Deficient performance can also include other actions or inactions by the lawyer that fall below the standard of care expected from a reasonable attorney, such as failing to object to evidence, making incorrect legal arguments, or failing to properly advise the defendant of their rights. Lesson 2. Resulting prejudice. The second prong of the Strickland test requires the defendant to show that the deficient performance resulted in prejudice to their case. This means that the defendant must show that there is a reasonable probability that, but for their attorney's errors, the result of the trial would have been different. In other words, the defendant must demonstrate that the errors were so serious that they deprived the defendant of a fair trial. Examples of prejudice might include a wrongful conviction or the imposition of a harsher sentence than the defendant would have received if their attorney had performed competently. Lesson 3. Understanding resulting prejudice. Unit A. Definition of resulting prejudice as an outcome that would have been different had the counsel not performed deficiently. Resulting prejudice in the context of ineffective assistance of counsel refers to an outcome in a criminal trial that would have been different had the defense attorney not performed deficiently. This means that the defendant must show that their attorney's mistakes or omissions actually impacted the outcome of the trial, rather than just arguing that the attorney should have done something differently. The defendant must show that the deficient performance of their counsel deprived them of a fair trial, and that there is a reasonable probability that the result of the trial would have been different had the counsel performed effectively. Unit B. Importance of proving resulting prejudice in addition to deficient performance. Proving resulting prejudice is an essential component of an ineffective assistance of counsel claim. While deficient performance alone may suggest that an attorney did not provide quality representation to a client, it is not enough to meet the high standards set forth by the Supreme Court in Strickland v. Washington. To prove an ineffective assistance of counsel claim, a defendant must show that the deficient performance had a substantial and detrimental effect on the outcome of the trial. In other words, the defendant must prove that the outcome of the trial would have been different if their attorney had provided adequate representation. This emphasis on proving resulting prejudice ensures that the defendant's right to a fair trial is protected. Without it, an attorney's mistakes or omissions could be overlooked if they did not ultimately affect the outcome of the trial. By requiring the defendant to demonstrate that the attorney's deficient performance had a substantial and detrimental effect on the outcome of the trial, the legal system can ensure that defendants receive the quality representation they are entitled to under the Sixth Amendment. Unit C. Examples of resulting prejudice, such as longer sentence, harsher punishment, or missed opportunity for plea deal. Longer sentence. If an attorney fails to present evidence or arguments that could have resulted in a shorter sentence, the defendant may be prejudiced by receiving a longer sentence than they would have with adequate representation. Harsher punishment. Similarly, if an attorney fails to argue for a plea deal or negotiate effectively with the prosecution, the defendant may end up with a harsher punishment than they would have received otherwise. Missed opportunity for plea deal. An attorney's deficient performance can also result in a missed opportunity for a plea deal. For example, if an attorney fails to advise the defendant of a plea deal offer or fails to adequately explain the consequences of accepting or rejecting a plea deal, the defendant may be prejudiced by missing out on a more favorable outcome. Conviction when the defendant may have been acquitted. If an attorney fails to investigate or present important evidence or witnesses, the defendant may be prejudiced by being convicted when they may have been acquitted with adequate representation. Waiving a viable defense. An attorney's failure to recognize or investigate a viable defense, such as self-defense or entrapment, can result in a defendant waiving a defense that could have led to a more favorable outcome. It is important for the defendant to prove both deficient performance and resulting prejudice in order to succeed in an ineffective assistance of counsel claim. Lesson 3. Burden of proof. Unit: a defendant has the burden of proving resulting prejudice by a reasonable probability. Yes, that is correct. In an ineffective assistance of counsel claim, the defendant must prove both deficient performance by their attorney and resulting prejudice. To prove resulting prejudice, the defendant must show that there is a reasonable probability that, but for the attorney's deficient performance, the outcome of the trial would have been different. This means that the defendant must provide evidence that it is likely, not just possible, that the deficient performance affected the outcome of the trial. The burden of proof for both deficient performance and resulting prejudice is on the defendant in an ineffective assistance of counsel claim. Unit B: explanation of reasonable probability is more than a mere possibility but less than a preponderance of the evidence. In the context of ineffective assistance of counsel claims, reasonable probability means that the defendant must demonstrate that there is a likelihood or chance that the outcome of the case would have been different if their attorney had not provided deficient representation. It is a standard of proof that falls somewhere between a mere possibility and a preponderance of the evidence. To meet the standard of reasonable probability, the defendant must show that the outcome of the case was affected by their attorney's deficient performance to a degree that undermines confidence in the outcome of the trial. This requires a showing that the deficiency in representation had a material impact on the case, such as causing the defendant to receive a longer sentence or miss out on a favorable plea deal. The defendant is not required to prove with certainty that they would have received a different outcome with adequate representation, but they must demonstrate that the deficiency in representation created a significant risk of a different outcome. The exact threshold for what constitutes a reasonable probability may vary depending on the specific circumstances of the case and the court's interpretation of the law. Unit C: importance of providing concrete evidence and not just speculation. Concrete evidence is essential in proving resulting prejudice in an ineffective assistance of counsel claim. Mere speculation or conjecture is not enough to meet the standard of reasonable probability. The defendant must provide specific evidence demonstrating how their attorney's deficient performance affected the outcome of the case. For example, if the defendant claims that their attorney failed to call a key witness, they should provide evidence showing how that witness's testimony would have impacted the case and why their attorney's failure to call them was significant. The more concrete and specific the evidence, the stronger the argument for resulting prejudice will be. Lesson 4. Causation. Unit: a need for a causal link between the deficient performance and the resulting prejudice. Yes, in order to successfully prove ineffective assistance of counsel, there must be a causal link between the deficient performance and the resulting prejudice. The defendant must show that there is a reasonable probability that the outcome of the case would have been different if their attorney had not performed deficiently. This means that the defendant must provide concrete evidence that the deficient performance directly led to the resulting prejudice, rather than just speculation or conjecture. Without a clear causal link between the deficient performance and the resulting prejudice, it is unlikely that a court will find in favor of the defendant in an ineffective assistance of counsel claim. Unit B: difficulty in establishing causation, especially if other factors were at play. Establishing causation between the deficient performance of the attorney and the resulting prejudice can be challenging, especially if there were other factors that contributed to the outcome of the case. For example, if the defendant had a significant criminal history or if the evidence against them was overwhelming, it may be difficult to prove that the deficient performance of the attorney was the sole or even primary cause of the negative outcome. Moreover, causation may also be difficult to establish if there were strategic decisions made by the attorney that ultimately led to the negative outcome, even if those decisions can be considered deficient performance. In such cases, it may be difficult to argue that the deficient performance caused the resulting prejudice, as it could be argued that the attorney's strategic decision-making was a contributing factor to the outcome. Therefore, it is important for the defendant to present concrete evidence and demonstrate a clear causal link between the deficient performance and the resulting prejudice in order to succeed with an ineffective assistance of counsel claim. This requires a careful analysis of the facts and circumstances of the case and a thorough understanding of the legal standards that must be met in order to establish such a claim. Unit C. Importance of showing that the deficient performance was a substantial contributing factor to the resulting prejudice. Yes, it's important to show that the deficient performance was a substantial contributing factor to the resulting prejudice. This means that the deficient performance must have had a significant effect on the outcome of the case, and not just a minimal or incidental effect. The defendant must demonstrate that there is a reasonable probability that, but for the deficient performance of their attorney, the outcome of the case would have been different. Establishing causation can be difficult, especially if there were other factors that contributed to the resulting prejudice. For example, if a defendant was convicted due to deficient performance of their attorney, but they also committed the crime and there is strong evidence of guilt, it may be more difficult to establish causation. However, if the deficient performance affected the plea bargaining process or resulted in the defendant receiving a harsher sentence than they otherwise would have, causation may be easier to establish. Lesson 5. Specific factors of prejudice. Unit of various factors that may contribute to resulting prejudice, such as loss of appeal rights, harsher sentencing, inability to obtain bail, or inability to enter into plea bargain. 1. Loss of appeal rights. If an attorney's deficient performance results in a guilty verdict or a harsher sentence, the defendant may lose their right to appeal the decision. This loss of appeal rights can significantly impact the defendant's ability to challenge the outcome of their case. 2. Harsher sentencing. If an attorney fails to adequately represent their client during sentencing, the defendant may receive a harsher sentence than they would have received with competent representation. This can result in the defendant spending more time in prison or facing other consequences that impact their life outside of prison. 3. Inability to obtain bail. If an attorney fails to adequately argue for the defendant's release on bail, the defendant may be held in custody for an extended period of time before trial. This can lead to loss of employment, housing, and other negative impacts on the defendant's life. 4. Inability to enter into plea bargain. If an attorney fails to properly negotiate a plea bargain on behalf of their client, the defendant may miss an opportunity to receive a reduced sentence or avoid a conviction altogether. This can result in the defendant facing more severe consequences at trial. Unit B need to show how the deficient performance affected each specific factor and led to resulting prejudice. Yes, when making a claim of ineffective assistance of counsel, it's important to identify and demonstrate how the deficient performance specifically affected each factor that contributed to the resulting prejudice. This requires a careful analysis of the facts and circumstances of the case, as well as an understanding of the legal principles and standards that apply. For example, if the deficient performance involved a failure to investigate or present important evidence, the defendant may need to show how the evidence would have affected the outcome of the trial or sentencing. If the deficient performance involved incorrect legal advice, the defendant may need to show how the advice affected their decision-making or bargaining power. It's also important to consider any other factors that may have contributed to the resulting prejudice, such as the conduct of the prosecutor or the testimony of other witnesses. To establish a causal link between the deficient performance and the resulting prejudice, the defendant must show that the deficient performance was a substantial contributing factor, meaning that it was more than just a minor or incidental factor in the outcome of the case. Unit C. Importance of considering the unique circumstances of each case when identifying the specific factors of prejudice. Yes, it is important to consider the unique circumstances of each case when identifying the specific factors of prejudice. The impact of deficient performance can vary depending on the facts and circumstances of each case. For example, if a defendant had a weak case and little chance of acquittal even with competent representation, the impact of deficient performance may be different compared to a case where the evidence against the defendant was weak and competent representation could have led to a different outcome. Similarly, the impact of deficient performance may be different depending on the severity of the charges, the strength of the evidence, and the overall strategy employed by the attorney. Therefore, it is important to analyze each case individually and consider all relevant factors when assessing the impact of deficient performance on the outcome of the case.